He died before they could kill him, not for lack of evidence, nor because of endless appeals, nor even for any mercy from the system. Simply, time outlasted justice. Florida, United States, year 2013. In a gloomy cell on death row, a man finally exhaled his last breath. It wasn't in the execution chamber, nor by the hand of justice. The life of this inmate, Gary Alvord, ended from natural causes after having spent the astonishing amount of 40 years awaiting his execution. 4 decades. He was not executed. He never heard the metallic sound of the heavy door to the block opening to take him to his final destination. He never felt the cold, definitive prick of the needle. His name was Gary Alvord, and his case, a judicial and human labyrinth, remains one of the most extreme and frankly disturbing examples of the limbo, inefficiency, and agony that the U.S. capital punishment system can create. This is the case of a confessed murderer who, one way or another, managed to never be executed. A living paradox that defies the logic of capital punishment. Gary Alvord was a man who, without a doubt, committed a brutal crime. He was found guilty, sentenced to death. And yet he outlived 11 presidents of the United States, from Richard Nixon to Barack Obama. He survived 3 failed execution attempts, moments when he was just minutes, perhaps seconds, from death. And most shockingly, he managed to spend 4 long decades at the threshold of his end, in the personal and legal purgatory that is death row. His existence became a constant question about the effectiveness and morality of a system that condemned him but was incapable of carrying out its own sentence. But who was Gary Alvord? What exactly did he do to earn a place in one of the most feared segments of the penitentiary system? And why, despite his sentence and the nature of his crimes, was the system that sentenced him to death unable to carry out its verdict? These are the questions that will guide us through a story that is as much a criminal chronicle as it is a study of the system's failures. This is the journey through one of the longest, most perplexing, and controversial death row cases the United States penal system has witnessed. A path full of unexpected twists, endless appeals, and a silent but constant debate about life and death. And perhaps one of the most forgotten, despite the magnitude of what it represents. Prepare yourselves for a story that will leave you questioning the true meaning of justice. The date that marked the beginning of the nightmare for the city of Tampa, Florida, was June 14, 1973. That day, in a home that until then had been a haven of peace, the lives of 3 women from different generations were taken in the most brutal way imaginable. The victims were Ruth Duggar, 61 years old, the family's matriarch, her daughter Susan, 34, a woman in the prime of her life, and the granddaughter, Denise, only 15, with her whole future ahead of her. 3 generations, united by blood and by a tragic fate, who met their end in a single night, at the hands of a single killer. How could one person sow so much terror in a home? According to the chilling police reports reconstructed after the scene and Gary Alvord's own confession, he was 29 at the time. His entry into the home was not the result of sudden rage, but began with a clear, cold intention: robbery. Alvord broke into the house, intending to steal valuables. However, something unexpected stopped him in his tracks. It was not a locked door, nor the sound of a blaring alarm alerting the neighbors. It was the simple but fatal fact of encountering someone else at home. The plan to rob, in an instant, took a much darker and more macabre turn. What happened next still shakes those who had to read or process the forensic reports. The details are harrowing and reveal methodical cruelty. Alvord, with unthinkable coldness, raped and strangled each of the women, one by one, in an act of intimate and prolonged violence. There was no mercy. There was no rush. The crime scene was described by the detectives who processed it as a silent massacre. The absence of gunshots or screams that might have alerted the neighbors or authorities made the act even more chilling. There were no noises to give away the horror. There were no outside witnesses to account for the victim's last moments. Only contained, intimate, and methodical violence that played out in the silence of that home. The report details that one of the victims, Denise, the youngest, the teenager who was just beginning her life, was found with clear signs of a desperate struggle. Her death was not quick, not an impulsive act. It was prolonged. It was cruel. The marks on her body told of a final battle for her life, a struggle that, tragically, she lost to her assailant's brutality. What kind of mind is capable of perpetrating such a level of atrocity without a single scream? Gary Alvord, to the Tampa police and to the authorities of other states, was not a stranger. His name was already in records, showing a pattern of problems and a criminal history that should have set off all the alarms long before this massacre. In fact, the most alarming detail is that he had just escaped from a psychiatric hospital in Michigan only days before the triple homicide. His documented history included a long list of crimes: robberies, erratic behavior that often ended in confrontations, physical assaults, and a series of psychiatric diagnoses painting a deeply disturbed profile. Doctors had determined that he suffered from paranoid schizophrenia and displayed extreme antisocial tendencies, a devastating combination that made him a latent risk to himself and those around him. This escape, not thoroughly investigated at the time, was a failure of the system that would have fatal consequences. After a brief interstate flight that took him across several state lines, Gary Alvord was finally captured in Georgia. What followed in the judicial system seemed like a clear and direct path to justice. A confession from Alvord himself, overwhelming forensic evidence that indisputably linked him to the crime scene, the undeniable atrocity of the murders. Everything pointed to the maximum penalty. But why would such an apparently straightforward case become a 4-decade labyrinth? The answer is not as simple as it seems, and it is here where the story of Gary Alvord transcends the crime to become a profound critique of the penal system. Gary Alvord was not a simple criminal, but rather a dark reflection of a system that failed to identify and treat his deep mental and social wounds. His story begins long before that fateful night in June 1973, on the streets and in the psychiatric hospitals of the United States. Born in 1944, Alvord had a childhood marked by instability. He grew up in foster homes, bouncing from family to family. The first signs of mental disorder appeared in adolescence, when he began to show episodes of paranoia, social isolation, and violent outbursts. He was diagnosed with paranoid schizophrenia, a disorder characterized by delusions of persecution, hallucinations, and, in some cases, aggressive behavior. These symptoms were combined with an antisocial personality that made him unpredictable and dangerous. He did not seek help, and when he received it, it was insufficient or inadequate. His stay in a psychiatric hospital in Michigan, from which he escaped days before the triple homicide, shows the cracks in the mental health system of that era. Psychologically, Alvord embodies the prototype of the mentally ill criminal, someone trapped in a cycle of untreated illness, isolation, and violence. His mind was a battlefield between violent impulses and mental confusion. In interviews conducted during his incarceration, he appeared evasive, sometimes coherent, and at other times totally disconnected from reality, which made it difficult to assess his dangerousness and potential for rehabilitation. From a legal perspective, his case raised complex questions. How should an inmate with severe mental illnesses be treated? Should paranoid schizophrenia be a mitigating factor or a reason to avoid the death penalty? U.S. legislation has varied on these considerations, but in the 1970s, understanding and application were limited, and Alvord ended up being sentenced to death. The judicial process was swift and forceful. The prosecution presented a solid case, detailed confession, physical evidence, and forensic witnesses who described the brutality of the crime. The defense tried to argue Alvord's mental incapacity, his psychiatric diagnosis, and his recent escape from the hospital as factors that diminished his responsibility. However, the court rejected these appeals. At that time, the criminal justice system was under intense social pressure to take a hard line against violent crimes, and the figure of a triple homicide caused public outrage. The defense argued insufficient mental incompetence to overturn the trial, and the death penalty was imposed without deep consideration of the accused's mental state. This trial marked a turning point in the discussion about mental health and the death penalty. Despite the conviction, the debate about the legitimacy of executing people with severe mental disorders began to gain strength in legal and human rights circles. During the following decades, the case of Gary Alvord became a symbol of this tension. While he served his sentence, he survived presidential changes, modifications in the law, and controversies over the ethics and effectiveness of capital punishment. Being on death row is, for many, living a sentence within another sentence. It is not only the deprivation of freedom, but an existence marked by prolonged waiting, constant uncertainty, and an almost absolute isolation that can be, in practice, as torturous as the execution itself. It is a judicial limbo, a space where time stretches and hope withers. In the reality of the US penal system, the death penalty, ironically, often transforms into an eternal wait, where bureaucracy and legal complexities become a sort of invisible barrier that delays the carrying out of the sentence. Is this mental punishment, this prolonged agony, a form of justice or an additional cruelty? Gary Alvord spent an extraordinary amount of time in this situation. 40 years. During that vast period, he witnessed how the outside world changed drastically, how presidential administrations came and went while he remained in his cell. He saw his own appeals rejected one after another, saw his execution dates announced, cancelled, or postponed. Each announcement was a blow, each cancellation a momentary reprieve, but also a prolongation of agony. Endless bureaucracy, complex legal labyrinths, and procedural errors, often inadvertent, became his protectors, though ironically so, during his prolonged existence. Gary Alvord's records noted 3 failed execution attempts. It is crucial to understand that most of these postponements were not due to a sudden wave of compassion from the system or public opinion, but to a series of technical or legal problems that highlighted the inherent flaws in the death penalty process. There were documented cases of expired drugs or problems with lethal injection protocols that did not guarantee a humane or effective execution. On other occasions, it was improperly applied procedures at earlier stages of the case, or unexpected last-minute judicial delays, such as the review of a new appeal or an intervention by a higher court. The harsh reality is that, although Gary Alvord was unequivocally sentenced to death, the capital punishment itself was never effectively applied to him. The system, in its attempt to execute him, was constantly frustrated by its own complexities. Could it be argued that the system's inefficiency in cases like this becomes a perverse sentence in itself? Psychologically, this indefinite waiting and the constant cycle of hope and despair had a deeply exhausting effect on Alvord. It is not surprising that studies on death row inmates show a consistent pattern. Chronic anxiety, severe depression, and overwhelming hopelessness are constant companions in the lives of these individuals. The awareness of an imminent but unpredictable death, added to extreme isolation and lack of control over their own fate, creates unbearable mental torment. In many of these cases, inmates do not end up facing the lethal injection. They die before being executed, whether by natural causes related to old age or the deterioration of their health under those conditions, or, tragically, by suicide, seeking to end a suffering they considered worse than death itself. Gary Alvord's story thus becomes a disturbing testimony to how the punishment of the death penalty manifests in much more complex and prolonged ways than the original sentence suggests. Is this the justice society seeks, or an agony self-imposed by an imperfect system? In Alvord's case, he died in prison in 2013 at age 69, before justice could consummate his sentence. The story of Gary Alvord is not just the story of a man, but the story of a system that often seems designed to fail. During those 40 years, his case became tangled in a web of appeals, procedural errors, and legal changes that made him a symbol of the contradictions of the death penalty in the United States. In 1976, the Supreme Court revalidated the constitutionality of capital punishment but established strict rules to avoid arbitrary executions. This brought a wave of new trials and appeals for convicts like Alvord. His legal team filed multiple motions, ranging from issues about his mental health to irregularities in the original process. Each was a battleground between justice and bureaucracy. During that time, Florida experienced several changes in its execution protocols. Different drugs were tested for lethal injections, some with questionable results. Public opinion was divided. Some demanded that the sentence be carried out no matter how long it took, while others denounced the cruel limbo in which these inmates lived. One of the cruelest ironies is that Gary Alvord, sentenced to death, lived longer than many other prisoners serving life sentences without parole. But his life was a slow agony, marked by waiting, loneliness, and uncertainty. Behind the legal file and the cold numbers, there was a human being facing a unique fate. Interviews conducted with Alvord by prison psychologists reveal a man who, at times, seemed to accept his destiny, and at others, was lost in memories and delusions. His letters to family members, some of the few human connections he maintained, showed a mix of regret, hopelessness, and sometimes contained rage. Prison transformed him, but did not destroy him completely. Experts in penal psychology point out that prolonged waiting on death row can cause irreversible damage to the mind. It is not only the death sentence that affects, but the constant uncertainty, the suspension of time, the between two worlds that the condemned live. Can we speak of justice when punishment is prolonged indefinitely? Is this waiting a form of legal torture? Gary Alvord's case is not just the story of a condemned man. It is a powerful question that hangs over the very essence of the death penalty in modern society. What is the purpose of capital punishment if its execution is delayed for decades, if justice cannot be fulfilled in times that reason and humanity would consider acceptable? The mere indefinite prolongation of waiting on death row, that purgatory of concrete and despair, does it not amount to a punishment more cruel and torturous than the execution itself? The mental agony of living day by day with the certainty of a violent end, without knowing when it will arrive, is a form of psychological torment that many would argue surpasses the physical brutality of lethal injection or the electric chair. It is a sentence to die 1,000 times before the last. This deep contradiction, this dichotomy between the purpose of punishment and the reality of its application, is not exclusive to the Alvord case. In recent years, we have witnessed a significant shift in the landscape of the death penalty in the United States. Several states have paused or, even more decisively, abolished capital punishment, precisely because of these ethical and practical dilemmas. The impossibility of guaranteeing quick and error-free justice, the exorbitant economic cost of prolonged appeal processes, and the growing awareness of human fallibility in an irreversible system have led many to reconsider the morality and effectiveness of the death penalty. From a legal point of view, progress has been painfully slow and at times deeply contradictory. While there have been significant advances in recognizing the vulnerability of inmates with mental disorders, the practical application of these guidelines remains uneven and is often hampered by the rigidity of the system. Modern jurisprudence unequivocally requires that inmates with intellectual disabilities or severe mental illnesses not be executed. It is an attempt to safeguard the human rights and dignity of those whose ability to understand or control is diminished. However, the definition of intellectual disability or severe mental illness often becomes a legal battlefield where the boundaries are blurred and subject to disparate interpretations by prosecutors, judges, and experts. The same diagnosis can mean life or death, depending on the state, the court, or even the jury. The case of Gary Alvord, though considered extreme due to its duration and the particulars of his mental health, is a brutally clear mirror that reflects all these systemic failures. In his story, justice was trapped in an impossible crossroads, between the pressing need to punish a heinous crime and the inability to do so in a way that was at the same time just, humane, and consistent with the ethical principles that a civilized society should uphold. His life on death row became a symbol of the cracks in the system, a constant reminder that sometimes the pursuit of justice becomes an odyssey that dehumanizes both the punished and the very process itself. The final question still resonates. How many more Alvords must there be before society finds a definitive answer to this moral dilemma? An unexpected ending, death in the cell, and the echo of unfinished justice. In 2013, the prolonged and stormy journey of Gary Alvord came to an unexpected end, not in the execution chamber, but in the solitude of his cell. The man who had waited for his appointment with the lethal injection for 40 years, 4 decades of agonizing anticipation, died of natural causes. The execution that had marked his existence never took place. His case, an anomaly in the annals of capital justice, was sealed in the archives. A story that few remember today, but which holds uncomfortable truths about the death penalty and the system that enforces it. Death row, That place, conceived as the last word in justice and retribution, in Alvord's case, revealed itself as a space of deep contradictions, endless waiting, and human tragedies that go beyond the mere application of the law. It was not a quick and definitive end, but a slow erosion of life, a sentence to perpetual uncertainty. What is the point of a death sentence if its fulfillment is postponed until the condemned's own life is extinguished by other means? The story of Gary Alvord, in its tragic outcome, forces us to reflect on who really won in this prolonged process. Was it justice that prevailed, even if it was by natural death? Or was it compromised by the inability to execute a sentence within a reasonable time? Was the punishment the real victor, inflicted not by the executioner's hand, but by the psychological torture of a 40-year wait? Or was it simply time, inexorable and silent, that rose as the supreme judge, dictating an end that escaped the control of any court or governor? The Alvord case remains a monument to the failings and ethical dilemmas inherent in the death penalty, a somber reminder that sometimes the search for closure can be prolonged until it fades into a purposeless agony. It leaves us with a disturbing question: is this the kind of justice we want as a society? We have reached the end of a story that forces us to look closely at the shadows of justice, of time, and of the human soul. The cases of Cameron Todd Willingham, Thomas Lee Gudinas, and Richard Gerald Jordan are more than legal files. They are echoes of broken lives, of irrevocable decisions, and of a system that at times leaves us with more questions than answers. What do you think? Do you believe justice was served in these cases? Do you consider that prolonging the wait on death row is a more cruel form of punishment than execution itself? Every story we tell is an opportunity to reflect on what we believe and how we want our society to function.